All right, beautiful. Good afternoon, everyone. Thanks for tuning into our webinar today. So today's webinar is it's about disciplinary action and terminations and really how to get the process right. So perhaps we should kick off with a bit of an introduction. So my name's Julian Hackenberg. I work for MyHR Australia, and basically my role is to provide HR support and assistance to our client base, which is made up largely of small and medium-sized businesses who just require support to deal with everything and anything to do with HR, including this sort of stuff that we're going to be touching on today. So disciplinary action and terminations. And with me today, I've got my colleague Robert. So he's with us today. So Robert, why don't you tell us about yourself?
Well, I'm General Manager of MyHR in Australia, as you know, Julian. Thanks very much for the opportunity to get involved in your session here today. Background has been with industry associations and large companies. So in terms of unfair dismissals, we've dealt with fairly formal, rigid procedures where an employee is backed by a union official, and I've also dealt with senior executives who have have had the assistance of lawyers to work through problems associated with employment. By and large, my observation is in most times you get a difficulty, you want to settle it if it gets to the point of an unfair dismissal claim. But the trick is, I think, Julian, is just to avoid the legal problem altogether, and that's what today's about. And I'm keen to help you and our viewers here to understand what they need to do to avoid problems when it comes to dismissal or disciplining or counselling employees.
Yeah, beautiful. And look, the tagline for today's session is, in effectively managing employee performance and conduct, employers need to enact disciplinary processes, which can include formal warnings and terminations. There are significant risks attached to these, as you mentioned, Robert. And so if you get it wrong, so you need to really focus on ensuring that you follow the correct process, of course. And really, that's what today's session will cover. A bit of housekeeping before we kick it off. So today's session is recorded. Recordings will be available afterwards on the MyHR website. So any questions will be recorded and available afterwards as well. So, if you do wish to ask questions, we're obviously available for those questions, but just use details that you're comfortable in sharing and submit only sort of anonymous details, I suppose. So we do have a Q&A at the end whereby, we can answer any questions that anyone might have. So today's topics, really just sort of looking at the basics. So, what are disciplinary processes? I suppose we're mindful that some businesses may not have had to deal with this sort of thing before, sort of smaller enterprises who've perhaps grown and brought on more employees. With that comes more complexity and the potential for, difficult or problem people. And so with that, we'll sort of touch on why they're important and when we really should be looking at using them as well. We look at the risks. So what are the risks around taking disciplinary action or undertaking a termination of employment? Both the legal, but also the risks internal within businesses as well, and looking to sort of manage those things as well accordingly. We'll go through an overview of a disciplinary process. There's generally a number of steps that need to be factored in, and some of them are not obvious steps as well. So we really want to make sure that we're getting that right, because really the process is, for the most part, the thing that we really need to make sure we've got down pat. And just looking at the practice as well. So what are the practical tips or practices that we really need to focus on? It's one thing saying, hey, this is the process. It's another thing actually practically managing that and managing the various bits and pieces that can come up along the way. Okay, so disciplinary action, the what, why, the when. So what is the purpose of a disciplinary process? So look, a disciplinary process is really a way of managing alleged misconduct or poor performance. At its core, a disciplinary process should encourage improvement in work performance and conduct and facilitate the management of poor performance and misconduct. Disciplinary processes should ensure that employers are dealing with matters related to conduct and performance in a reasonable manner and in accordance with procedural fairness principles. And it's an opportunity to reset conduct and performance expectations. They can provide employers with protections from claims such as unfair dismissal claims and the like. Why do employers need to undertake disciplinary processes? As we'll see, the Fair Work Act, which is the primary piece of legislation that we need to be concerned with when it comes to employment and managing employees, has a criteria for considering harshness when it comes to unfair dismissal. This criteria includes matters which would ordinarily be catered for in a disciplinary process, such as the reason for the dismissal, whether the employee was notified of the reason and given the opportunity to respond. It's important to understand the actual nature of the issue that we're dealing with as well, because how we respond to that could be different in different circumstances. Now, poor performance could be managed differently at the initial stages, certainly, to an actual instance of misconduct. And how we respond ultimately from a disciplinary standpoint could be different depending on the specific nature of the misconduct itself. Ultimately, misconduct is misconduct. So if we're undertaking a disciplinary process in dealing with that, it's very much going to be the same. But it's also important to understand the matters that we're dealing with, because they do have different legal definitions. So serious misconduct is defined in the Fair Work regulations. And it can be quite a high bar to reach. And there are implications in terms of whether or not it might be reasonable to terminate employment as a result, or whether there is a requirement to provide an employee notice and that sort of thing. So we want to make sure that we're developing a clear understanding of what we're dealing with. Are we sort of meeting that threshold of serious misconduct, for example? And look, a real big question I think employers often come to us with is when should we undertake a disciplinary process? This is arguably the most challenging part. That is, determining when it's appropriate to undertake a disciplinary procedure. While it is a management tool and one that is supported by the legislation, it can be a big stick approach. The formal nature of disciplinary procedures can create stress and anxiety for people on the receiving end, as well as those managing it as well. So prior to commencing a disciplinary procedure, it's important to consider whether it be more effective to deal with the matter informally. Striking the balance between a formal and an informal approach is really one of the key skills of a manager. Ultimately, it's the process that you would likely need to undertake. That is a disciplinary process to manage employees. But it's really just understanding, at what point do we sort of strike with that? So Robert, looking at disciplinary action or disciplinary processes from a sort of big picture standpoint, what do you think are the most important things that employers need to consider before commencing a disciplinary process?
Well, I think Julian, you have covered most of those points off really well. But probably the most important thing is just to identify and concentrate on the facts of the situation. You've got to understand those facts and understand specifically why that situation is equals unsatisfactory work conduct or work performance. And then I think you've got to ask yourself, with respect to the individual you're looking at, would you apply the same rule and standard to everyone else? The point there is consistency and uniformity. If your expectations are the same for every individual, including that individual, then you're more or less got a green light to proceed. And then it's just a question of where do you start the process. You don't want to jump straight to a termination, or possibly even a formal warning, depending on what the issue is. But just, I think, understanding the facts, understanding the implications for the business and the employee, and just ask yourself, am I treating this person in a consistent and uniform way? Probably the three things I'd be thinking about prior to starting off the process.
Yeah, definitely. And sort of taking it a step back, even before thinking about disciplinary procedures and that sort of thing, how should employers really set themselves up for success?
Well, I think it's preparation and confidence with the process. These situations can be very intense and full of emotion, and quite honestly, the employer hasn't got the luxury of emotion here. There's a process to control and manage, and it's really important that the employer representative understands the clear purpose of the discussions and take the process through each of the stages as outlined in our process sheets. The worst situations I see is when an employer gets embarrassed or wrong-footed or gets a bit emotive about the circumstances. It's at that time control gets lost and you get some really bad decisions, and invariably we're coming in to clean up the mess. So I think that's pretty critical. Just be prepared and stick to the facts. And the other thing, of course, is just keep an open mind and listen. You're there to hear some allegations, put some allegations to someone and hear their response. You're not there to judge it. You just want to hear the response, get the information, so you're in a good position going forward.
Yeah, I think that's a key thing. Is it's more of an informational exchange, and obtaining that information from the employee rather than and sort of holding back that tendency to want to sort of get stuck in and really send a clear message.
You've got to be guided by the process and not by your emotions and what your expectation is. It's a passive role, but it's a very controlled and managed passive role.
Yeah, good way of putting it. All right, so I guess now it's a matter of looking at the risks. So I suppose we've sort of broken this down into a sort of couple of areas. We've initially got our legal risks, and of course there's clear legal risks around this sort of stuff. But then, what are the other risks? So what are the risks around, not adequately dealing with this sort of stuff? What's the impact of, not knowing or understanding how to run a disciplinary process, or not having the confidence to do that, and how can it impact on the organisation more broadly than that? So if we start with the legal risks, I suppose the biggest one that comes up is unfair dismissal. It seems like every day or two there seems to be a high-profile unfair dismissal case that's been run. But so of course unfair dismissal protections need to be considered when it comes to undertaking disciplinary processes. It's important to understand where they apply, because it can be different for small employers as to larger employers. A common thing that I think we find a lot of clients don't realise that some casual employees can have protections from unfair dismissal as well. And I suppose really looking at really looking to understand what that risk is, when it applies, and what are the steps that we need to do to avoid that risk coming into fruition. So, and I think Robert will touch on some of the things that are required under the Fair Work Act to avoid unfair dismissal claims down the track as well. Other lesser known risks, I suppose, are around general protections or adverse action. So that is really taking adverse action against an employee due to them exercising a workplace right, for an example. So that's clearly prohibited under the Fair Work Act. And in some respects, employees can interpret disciplinary action as taking adverse action. So that's where we need to make sure that we've got our ducks in a row in terms of process to avoid those sorts of claims coming about, as well as things like breach of contract and claims of that nature can be avoided through disciplinary processes also. That sort of takes us to the other risks. So, there are clear risks around company culture, cohesion, reputation of the business as well, health and safety, and also workers' comp premium costs as well. So, if we're not sort of adequately dealing with matters of misconduct, through an appropriate means through like a disciplinary process, then, that could have an impact on company culture. It could have an impact on retention, attracting staff. It could have an impact on workers' comp claims. Particularly stress claims have been an increasing component of the workers' comp landscape over recent years. Bullying and harassment type claims. What processes do we have in place to deal with those? And of course, ultimately, disciplinary processes would take a role at some point if we're coming to the point of dealing with allegations of bullying and harassment after we've done investigations and the like. So I think it's a really challenging thing for a lot of small and medium-sized businesses is, as we grow and employ more people, ultimately that's going to lead to differences of opinion or differences of working, potential issues around performance and conduct. What do we have in place to manage that as that comes about? And certainly part of the management tools that employers have would be disciplinary processes to manage misconduct and poor performance. I mean, Robert, if we go to the sort of top issue there, unfair dismissal claims, why are they so burdensome for small and medium-sized businesses, do you think?
Well, I think it's a burden probably where they don't have a process or a management plan, but they are burdensome and a nuisance because basically they suck up so much of your management time. You've got a form is lodged, you've got 7 days to respond to it. I've had situations where companies have had that form lodged on Christmas Eve with a whole series of public holidays, but we've got a 7-day timetable to respond. So there's that. And then there's just the preparation. So as soon as you have to get someone else involved externally to an unfair dismissal claim, you're burning up time, going over old history and having a look at a circumstance that's behind you, not in front of you. So from that point of view, I think it's just the distraction to management focus, which is the real burden for these things. So the trick here is, of course, the unfair dismissal can also cost you an amount of money if it's not done properly. I mean, the damages there are up to 6 months. Generally, they're 95% of them are settled, but there's still costs there. So it's just really not only the time, but the dollar cost associated with these things.
Of course, yeah. Of course. All right. Well, let's have a look at maybe a bit of an overview of a disciplinary process in that case. So, we've listed 6 or so steps there. So investigate the matter is really the first one, and that sort of goes to some of the points you were making, Robert. There is really looking to try and establish the facts, or as near as possible to understanding what we think has occurred prior to going down the next steps is, and it can be difficult. I think we've seen a lot of reactive clients in the past where they think they know what's going on and sort of rush into rush maybe to step 6 before they sort of get steps 1 to 5 sort of under their belt altogether. But really it's looking to
or Julian, step 7, terminating the employee.
yeah, exactly. Really looking to understand what do we think has happened, why has it happened, investigating the matter really. Who do we need to speak to? Can we get some information, interviewing employees, reviewing documents or other material, CCTV footage, if appropriate as well. Really trying to build a sufficient understanding of what we think has occurred. The next step from there is really to advise the employee of the alleged conduct. So really what we're wanting to do is put the allegations in writing. So what we think has occurred and why we think it's an issue. Is it a breach of company policy or their employment contract? What are the ramifications of the misconduct? So the employee knows coming into the later steps of meeting that what the potential ramifications are. And it really inviting them to a meeting as well. So it's really investigate the matter, advise the employee of the conduct, why it's an issue, and hey, we think that this has happened. We want to invite you to a meeting to put your side of the story forward so we can consider that before we take any further steps. So we want to provide the employee with a reasonable opportunity to prepare for the meeting. So sort of best practice approach would be to provide the employee 24 to 48 hours notice of that meeting. Is that your understanding, Robert, there? And if so, why is that important?
I think that underlying concept for these tribunals goes back to the old concept of equity or fairness. So if you treat the person fairly and reasonably, and then you wind yourself up in these situations, you come into the tribunal with clean hands, and clean hands is what you want. If there is anything about your conduct that seems unfair or unwarranted in this sort of environment, that'll tell against you. Yeah. And that's what helps in escalating dollar outcomes in these things. The process is important. Is important. Obviously having a valid reason and going is underpinning all that. Yeah. But I just think that fairness is the key thing that everyone has to understand, and it's fairness in terms of the concept of the reasonable person, which is a common term used when describing what's fair and reasonable in these circumstances, Julian.
Awesome. So our third step there is obtain the employee's response. So usually this is done in a meeting. The employee's given the opportunity to present any extenuating circumstances, if there are any, or just provide a response to whatever the allegations might be. As Robert mentioned previously, it's really an informational exchange, trying to get the information from the employee in order to consider that. So, this is what's alleged to have occurred. You were, late on X number of days and over a particular period. What do you have to say about that effectively? What are the reasons? What are the things for us to consider? Before deciding whether any action should be taken against the employee. So really, it's in some senses, it's a really straightforward meeting in that case. But as Robert's mentioned as well, there's usually a lot of emotion, a lot of confusion sometimes as well. And so they can be more difficult to manage than that, particularly if we're dealing with a range of issues and some of them more complex than others. But fundamentally, it's a matter of giving the employee an opportunity to respond to those allegations and that procedural fairness before we take it to the next step. So Robert, maybe a practical question. I mean, who generally should attend disciplinary meetings?
Yeah, I mean, the thing you don't want to do is escalate the situation and suddenly have the employee with a representative, unless of course they ask for it, and then of course you're obliged to allow them. But as a general rule, it's handy to have a witness there to note effectively what's going on. I mean, with you actually conducting the meeting, there's enough for the individual conducting the meeting to go on, but hey, it's handy having someone there just keeping a track of what's happened, so you can have your notes to refer to at the end of the meeting. So that'd be the general rule. Now, because if they've got a representative, well, we've got the hired guns in the room, so it's a consideration for the business to get an external representative in to match up. As I said, the greatest success with these matters is not getting to that point, and for the managers to be coached and mentored to handling the situation, so it seems like a day-to-day operational management exercise, not the precursor to some massive legal problem. Because you don't have a legal problem at this stage, do you, Joel? It's just you're talking to someone about a difficult situation, and your expectation is that through some sensible discussion, that'll get resolved one way or the other.
All right, excellent. And so I suppose the next step really is considering the employee's response, whether further information is required, considering whether there's any extenuating circumstances. Are there other things that we need to consider? So, for example, if we're considering termination, it might be appropriate to consider things such as the employee's tenure, what their track record has been as an employee, et cetera, et cetera. So we're considering all of that information. What policies do we have in place? Have we made it 100% clear to the employee that this sort of conduct is not acceptable? Have they signed off an agreement with that? All of those sorts of things to really reinforce that we've done. We've set the expectations from the outset, and it really is the employee who hasn't met those expectations. And then look, it's really determining the outcome. So considering the most appropriate outcome. Disciplinary outcomes can range from a warning, through to ultimately, termination of employment as well. Of course, there may not be any need for termination, so any need for a warning or disciplinary action at all, depending on the circumstances and depending on what the findings are and what the employee's response is. But yeah, it's really looking at determining a reasonable outcome, which I suppose, Robert, is easier said than done. What do you think? What are the things that you're really thinking about when determining an appropriate outcome for after a disciplinary process?
Yeah, I think just whether the weight of your response is appropriate to the action you're trying to correct. So, for a person who's for their first time, been late because of a bus strike or something like that, well, that's probably an acceptable explanation for why someone's late. So in that instance, you don't want to issue a warning. So that's pretty obvious. But I mean, it just gets to the point in some of these issues where whether the warning in some instances should be a first and final because of the graveness of the conduct, or indeed whether it's a first or second warning. Just trying to understand what's the appropriate action to take. Yeah, that's the main thing, I think. Yeah.
Awesome. And then, of course, the final step is notifying the employee of the outcome. So, of course, we want to do that in writing, first and foremost. And look, that could be a challenging thing to do. It's always recommended, I think, to meet with the employee and advise them of what the outcome is, and then put it in writing and have that available in their personnel file as well. But yeah, so that really is the broad overview, and really a lot of the work's done at those initial stages around getting your information together, really understanding, what our policies and procedures and contracts say, and then sort of managing the meetings and considering all the information before determining the outcome. And then we get to that point of notifying the employee of what the outcome is. And of course, different outcomes are going to lead to different challenges. Issuing a warning, it might be a fairly straightforward conversation versus, terminating employment could be a much more difficult one. And of course, there's a bunch of administrative things that need to be done along those lines around managing an exit from the business in terms of company property, how much notice does the employee need to be provided, whether they're paid in lieu of notice, and what do we need to include as part of that, and so on and so forth. All right, so I think we've touched on this section 387 a little bit. So this is the fairness criteria around terminations. And as we mentioned, a lot of these things are addressed through that disciplinary process, which is what makes a disciplinary process so valuable when it comes to managing misconduct and unsatisfactory performance. But Robert, so these points really go to unfair dismissal risks that we spoke about earlier. In terms of unfair dismissal claims, where do employers generally get caught out? Is there a particular area that employers tend not to get right?
I think it's just it's timing, really. It's just as we said, people wanting to shoot off the hip and get to the finish line without going through the obstacle course first, right? You really got to navigate yourself through the process, and you've got to allow the time to do that. So, and again, I've said this before: listening and keeping an open mind. You can't be walking in there looking like you have made up your mind. I've had circumstances where a discussion's been had, and at the end of the discussion, the employers have handed over a pre-drafted termination.
Right.
Right. So clearly, there is no intent on the employer side to listen. The decision's been pretty much predetermined, and it was, in that instance, it was fairly evident that the employer was not interested in the employer's response whatsoever. So I think that's probably a common trap for people involved in this sort of process, John.
Yeah, right. And we've got down written down the bottom there, written warnings. I mean, a common question we get is how many warnings do you need to give an employee before dismissing them?
That's a hard one, isn't it? So I've worked in major work sites where, of course, there's got the 3-letter warning system, and the warnings all have a shelf life, and you go through that the palaver. But in a place where you don't have that sort of regulation, again, it's just what's the nature of the conduct, right? If someone is a recent employee and breached a safety requirement that could have injured someone, right? You might give them the benefit of the doubt once, but if it ever happens again, they'd be gone, right? Depends on the work environment, of course. You're talking about an industrial blue-collar environment, well, or a technical environment where you've got chemicals and other things involved, that'd probably be fair and reasonable. But in terms of warnings for lax conduct, they sort of telescope between 3 to 6 months before they run out of puff or go again. It's very much dictated culturally by what has happened previously on sites for larger employees. But as a general rule, I think unless it's a pretty severe thing, your warnings would have at least a 6-month life on it, 3 to 6 month life on it, depending. Yeah.
Cool. Yeah. So excellent. And look, we do have a question around written warnings as well. So it's probably good to say, are written warnings compulsory? And I think what we're saying there, Robert, is, it sort of depends on the matter, the work environment. The employee's tenure could come up in terms of warnings precedent in terms of the work environment inside as well. It's sort of considering a range of matters. I think the short answer is they're not compulsory, no, but they may be prudent and wise and necessary in some instances.
I noticed there was another question there about refuting responses and not telling the truth. I think that is always open to you, but you don't have to do it in the meeting. You can do it after you've considered the employer's response. The more time you take to consider someone's response to your allegations, the better off you are. Now, there is no reason why you need to shoot off the hip straight away. You can always wait, give yourself a bit of time, and show that you've been considered in your response. Yeah.
Amazing. All right, so equity, a fair process. So far we've focused on process. We've gone through a general overview of disciplinary process and how and why we undertake that process. It's time to look at some of the practical things, such as how to practically handle a disciplinary process, considering that it can be a stressful situation and can cause disagreement and conflict and an overall unsettling feeling. So what are some of these practical tips that you've got for us here, Robert?
Yeah, well, I think they're all there. It's just restating the obvious, I suppose. I mean, at the end of the day, you're a manager managing a situation. And like any situation that requires management, there's processes and procedures you've got to observe. And if you don't follow the processes and procedures in any sort of sense, whether it's operation or health and safety or compliance with accounting practices, you tend to get into a bit of bother. So, I think just because you're dealing with a person that is able to get under your skin or make you react. You can't let that happen. You've got to remember you're just managing a situation at work, and you just got to go through the process. So I think staying calm, listening, recording, and taking time to consider what's been said to you, they are probably the best tips, which we've talked about before, but I'm pounding them again, Julian, because that they are the golden rules to this.
Awesome. Yep, I think you're right. I think that's the thing is that it may not be like the sexiest message there is, but it's really an important message in terms of managing this stuff. Is it sort of staying focused, staying on track, following that process, taking the emotion out, and really just dealing.
And that's what that formula is all about. The summary formula at the end is just a simple way.
Yeah, absolutely. Absolutely. So that
if and that for a takeaway page, that's the takeaway page you have.
Yeah, definitely. Definitely. Did you want to talk us through that formula as well? Just to
well, I suppose it's just my observations of what I've had to deal with over an extensive period of time. I mean, Section 387 is given; it's in the Fair Work Act, and you have to observe it. Facts are always important. Emotion is a distraction. The only emotion that you can afford to contend with is the emotion of the employee. And in that situation, the job's on you to let him have his vent or her vent or of the situation and decide when's the right term to get them back on the path and talk through the issues. So you're going to take your emotion out of it and understand you might have to manage a disgruntled employee's emotion. And of course, this whole process is based on, as I said, the old concept of fairness and equity. So the way you handle these things have got to be seen as reasonable, and the process gives you the path. So you follow the process, it'll give you the best opportunity there to resolve these issues with the minimum of cost. And that's what our experience has shown us. I mean, Jason, a co-founder of MyHR, we're alike here on this. We know the following this sort of process will deliver you a consistent result and a decision that will stick, right? And even if it does go to a tribunal or commission, the fact that you've gone through this puts you in the best position, right, to defend your actions. I mean, Julian, you were talking about workers' compensation claims and bullying claims. I just had someone on the phone about a bullying claim because of poor performance. And of course, if you follow the process, you're able to demonstrate a robust defence that is recognised in these laws and regulations. So when people put in stress claims or bullying claims, one of the detailed defences is for an employer is that they were following a management process, a disciplinary or counselling process. So if your process is robust and you can show it exists and it's been managed, more importantly, fairly and reasonably, well, you're in a good position to defend these claims.
Beautiful. Well, mate, I think that's a good place to leave it. I know we've had a couple of questions come up throughout the session. I suppose if anyone's got any, if anyone's got any other questions, feel free to
contact us.
Feel free to enter that into the chat or the Q&A section now.
Yep.
We can tackle those questions now if you like. Alternatively, feel free to get in touch with us. Obviously MyHR, we've got our website myhr.works. There's a bit of information about Robert and myself there on screen now. There is a question actually that's popped up.
Oh, great.
A couple of questions, in fact.
Oh, awesome.
So maybe we can go question. Robert, does the disciplinary action process apply to poor performance or only conduct issues?
Both. Okay, so if you're talking about poor work performance and you're going through a performance improvement program, a PIP or something like that, more, the information collecting is probably easier because it's generally, finding, particularly in a sales environment where someone is not performing and hitting their targets, you've got that process where you're following, and that process more or less follows the same reasoning and rationale as the ones related to conduct. They probably take longer and there's more in it, as you would know. Work performance can be quite quantifiable, and generally you allow an amount of time for improvement of performance. If it's sales that are reported monthly, well, I suppose you stuck to the monthly reviews of the sales results, for example.
Yeah. Awesome. I think that hopefully that's answered your question there. And the other one is, what is a reasonable time frame to allow the employee to respond to allegations?
Yeah, probably a day or two at least. Hey, unless you're.
I think that's getting to the time frame to notify them, and then.
What is reasonable time to allow the employee to respond to allegations? Well, I suppose if you provide them with a list, so the process I get to is, here's your list of allegations. Here is why they're a problem. Can we have a response, right? So they may want to give that to you immediately, or you might not, or you might decide not to take that approach. So
yeah.
There's always the opportunity. So if you start this process off on say halfway through on Monday, by Thursday or Friday you want to be meeting again to follow up on what's being said, right?
Yeah.
Because that's ideal. Now, if the response to the concern is one like, I don't really care, I don't think it's an issue, I'm not doing it, well, you're sort of straying into not complying with the reasonable management request. So you might be able to accelerate that there and then. It just depends on the circumstances. But, our advisors on the phone are great at this, Julian. They're just able to give you that contemporaneous, immediate advice. So you can judge this. There's no hard and fast rule, unless, of course, you've got, you've written some sort of unionised workshop that tells you what you've got to do, or in the public service or something like that. But, if you're not burdened with that, use our advisors. They are awesome at being able to assist in these things, Julian.
That's the thing I think we outline in terms of the process. Really, they're probably more principles than anything in terms of steps that need to be undertaken. In terms of the hard and fast, when, where, and that sort of thing, I suppose there's an element of flexibility depending on the exact circumstances and how the employee responds.
Absolutely. Well, it's been a good session, hasn't it, mate?
It has. I think. Yeah.
We ought to do it again, no?
Absolutely. So I think that's all the questions we've got, unless any final opportunity, if anyone's got any questions they want to ask. Otherwise, we might wrap it up there. Thank you for everyone in attending. It's been as Robert said, it's been an enjoyable session, and it's been a pretty good topic to cover, I think, and one that a lot of our clients have difficulty with. So it's a good one to sort of spread that message and provide a bit of information. Of course, if you want to look into MyHR further, feel free to have a look online, myhr.works. You could track Robert or myself down as well and have a bit more of a chat about disciplinary processes or anything else. So thank you so much for your time.
Awesome. Thanks, Julian. Cheers. Right.